bankruptcy if there is no agreement on the settlement. Holy smokes. Welcome to episode 400 of College Football's Peek Around the Corner with your host, Greg Pflugar. We cover everything in college football because we love everything in college football. And if you do as well, please subscribe to our channel. Smash the like button. If you like our content, share the video with your family and friends. Let's not waste any more time. Ross Dellinger article published late last night. We provide a link in the description box. You can read the whole thing. The documents. NCAA could face $20 billion in damages. Bankruptcy if proposed settlement offer isn't agreed upon. Amelia Island, Florida, if they reject a proposed settlement offer, officials from the NCAA and power conferences stand to face a catastrophic $20 billion in back damages, as well as risking bankruptcy filing, according to documents obtained by Yahoo Sports. The two-page document was circulated among the power conference presidents and administrators on Tuesday as ACC leaders met in their annual spring meetings in Florida. It details terms of a potential settlement in the House Hubbard and Carter antitrust cases, a trio of legal challenges brought against the NCAA and its 5 power conferences seeking back pay for various athlete compensation elements. The settlement, believed to be in the final stages of adoption, consists of 3 main concepts: billions in back damages, a new compensation model permitting schools to share as much as $22 million annually with athletes, and a cap system, and an overhaul of the NCAA scholarship and roster structure. Documents specify, perhaps for the first time in writing, the total amount in back damages owed to athletes for the use of their name, image, and likeness before the NCAA lifted NIL prohibitions in 2021. That amount, that number in back damages is $2.776 billion. The school distribution will be reduced by about 1/5 over the decade period of the settlement, or about $160 million per year. The NCAA annually distributes more than $700 million to its members, most from ticket sales and television rights agreements of the men's basketball tournament. Power leagues are anticipating a reduction of $1 to $2 million per year in distribution, according to the document. Aside from the financial figures, in 1 week before a potential adoption of the settlement, the document answers some vexing questions and leaves others unresolved. In what would be a significant element in the settlement, the court is expected to reaffirm the NCAA's remaining rules under compensation, including the prohibition on booster payments if they're not true NIL, the document notes. While a settlement would not eliminate collectives, it would provide schools with an economic incentives to bring them inside the university. The settlement, as well, develops a new enforcement infrastructure, specifically targeting pay-for-play rules around booster-led collectives, an infrastructure supported by the court's affirmation of the NCAA compensation restrictions. The restrictions, compensation in around the NIL collectives. This could potentially resolve a sticking point for administrators who believe that the settlement does not address what they describe as the Wild West environment across college sports recruiting in an era of open transfer and unregulated NIL payments. The settlement leaves open the possibility of athletes being deemed employees. The settlement can be revisited and revised if athletes become employees by either the courts or by voluntary nature. And I think this needed to be done. I will go over after we get done with the article. But the settlement leaves the possibility of athletes being deemed employees. The agreement permits an adjustment to the employment model with collective bargaining, a concept that many feel is necessary for a more long-term solution to the athlete compensation idea, and I am one of them. The settlement isn't perfect. As the document notes, it does not protect the NCAA and conference from future lawsuits brought by state attorneys generals, does not preempt state NIL or revenue sharing laws, or offers no real ruling on Title IX's application in such a compensation model. The Title IX remains at the campus level to be applied. The document notes Jeffrey Kessler, another plaintiff attorney in the case, believes the Title IX issue will eventually be resolved in the courtroom. The courts will decide, he told Yahoo Sports. It doesn't impact us. If we have a settlement, we'll negotiate a system in which athletes will be compensated. The degree in which Title IX applies will be determined by the courts. And finally, for many school administrators, the sticker shock exists. The $30 million price tag, a startling figure for an industry that has only provided athletes with mostly non-cash resources, is about 20% of the average athletic department budget of public schools in the ACC, Big Ten, SEC, and Big 12. However, without a settlement, college leaders risk another loss in court. They're going to have another loss in the courts. Even with this settlement, they're going to lose again. However, they're going to need to reach a settlement here with these three antitrust cases, the biggest one being the House versus NCAA. They're going to have to settle. They're going to have to vote on it. They're going to have to get it done. $2.766 whatever billion dollars is a whole lot less than $12 billion, $16 billion, could go all the way up to $20 billion in damages. Get it done. I like the idea that they've left open the possibility. I think they know the reality of this. At some point, these student athletes are going to be deemed employees. They just are, because they're going to need collective bargaining to protect everybody from the courts, from future lawsuits. The student athletes are going to have to be represented. They're going to have to be represented. There's going to have to be a collective bargaining agreement between the student athletes and the conferences. And this is what we've been saying at Peek Around the Corner since episode number 1. The great manifesto that we put out, August 10th, 2022? Sure, this is not the perfect settlement, not the perfect document, not the perfect resolution. But it has to get done. So get it done before or on May 23rd. And then they're going to get challenged again. They're going to try to get codification from Congress. That's probably going to fail. And then eventually, Tony Petitti and Greg Sankey will get on the ball and convince the presidents this is our only pathway to get the student athletes collective bargaining agreement among everybody. And let's push this great sport that we love, college football, forward into the modern era. Put down your comments and thoughts in the comment section below the video. Let me know how wrong I got it once again. Settlement should happen. It's going to happen. It's going to happen on or before May 23rd. We're 8 days away. We got an 8-day window. Get it done. Get it done. And then there's more work to do. Until next time. From all of us at PATC to all of you, please you all take great care of each other. Thank you so very much.